Has somebody hurt you or told you they are planning to hurt you? Have you left an abusive relationship? Do you feel distressed and afraid? Is somebody harassing you to the point that you fear for your safety or the safety of your family? Is someone threatening you with the release of sexually explicit photos? Has anyone been following you or constantly calling, texting, or contacting you? Have you ever wished you had a legal way to keep a person from having any contact with you? If so, you may want to go to your local courthouse and apply for legal protection, which is called an injunction for protection. You do this by filing a petition for an injunction with the clerk of court, who keeps the files and records for the court. In this video, you will learn about this kind of legal protective order, how to file it, and next steps. There are 3 sections that play one after the other. You can click on any part you'd like or watch the whole video. You'll also find a list with links to all the online resources we mentioned. Your petition for an injunction is a sworn statement that is reviewed by a judge, who then decides if there is a lawful basis for a court order requiring a particular person to stay away and have no contact with you. As the person filing for the injunction, you are called the petitioner, and the person you are filing against is called the respondent. Together, you are called the litigants. If you are a minor under 18, your parent or legal guardian must file on your behalf. If you are a parent or guardian filing to protect your child, the correct way to begin the petition is to write at the top the parent or guardian's name and relationship, and under that, on behalf of, and the child's name. The full name of the order you are asking for is an injunction for protection against domestic violence, which can also be called an injunction, or a restraining order, or a protective order. Once you file a petition for an injunction, the judge will review it and take one of 3 possible actions. First, the judge may grant the petition, issue a temporary injunction, schedule the case for a court hearing within 2 weeks or less, and have the respondent served with the notice of hearing. The second possibility is that the judge does not issue a temporary injunction, but does schedule the case for a hearing within 2 weeks or less. If this happens, the respondent will be served with the notice of hearing, but no protections will be in effect. The third possibility is that the judge could deny the petition outright, meaning the case will not be scheduled for a hearing, the respondent will not be served, and the case will be dismissed. We'll show you what to do if either of these last 2 things happen.
I have 3 kids and no job or money. When my boyfriend isn't hitting me, he's threatening to hit me. I'm trapped.
I married my wife 3 years ago, and we've been separated for 3 months. She's bipolar, won't take her medications, and is constantly showing up at my job and new apartment, threatening me. I'm so afraid of her.
My 20-year-old grandson has been living with me since he was evicted. He uses drugs, steals from me, and last night he pushed me to the ground. I don't want to hurt him. I just want him to get some help, and I want some peace.
I've been married to my husband for 11 years. He's always been verbally threatening and abusive. Last year, he hit me, and now it's much worse. He lost his job 2 months ago, and now he keeps saying we would both be better off dead. He has guns in the house, and I'm really afraid that if I don't do something, I'll end up on the news as the victim of another domestic murder-suicide. I'm terrified.
Although each of these situations is very different, All these persons are eligible to file a petition for the most widely used type of injunction, called a domestic violence injunction. You can file a petition for a domestic violence injunction when the respondent you are filing against is a family or household member. Under Florida law, family or household member means spouses, former spouses, persons related by blood or marriage, persons currently living together as a family or who have done so in the past, or persons who have a child together, whether or not they have been married. With the exception of a petitioner who has a child in common with a respondent, the litigants must currently reside together or have resided together in the past in the same single dwelling unit to be eligible for an injunction.
That's great, but I can't afford to file a domestic violence injunction or protective order or whatever you call it. I sure don't have any money for a lawyer.
There is no charge for you to file a petition for an injunction in Florida. You don't have to have a lawyer, and you can file it on your own. You can ask the clerk of court if there is a domestic violence shelter or advocate in your town who can help you with your petition. Or you can reach out to law enforcement or legal aid for information. And you can always call the domestic violence hotline or go online to find assistance. Now we'll show you how to prepare and file for a domestic violence injunction on your own. We'll show you other types of injunctions so you can choose which will work best for you. You can get all the forms you need to file for an injunction from your local clerk of court or at a special website online. You can also get a form that will help you keep your address confidential. The clerk has all the forms related to the petition for both litigants. If you go to the clerk's office to complete your forms, the clerk is required to make sure that you have privacy while you complete them. The clerk may have a private room where you can go, so that the respondent cannot harass or threaten you while you are there. If there is a domestic violence advocate there, you can meet privately and complete the forms. Or you can take the forms with you if you need to get more detailed answers to finish them. If you prefer to complete the forms online, you can go to a user-friendly website that will take you through the petition. Then you must print the petition, get it notarized, and take it to the clerk. Or you can just print the petition and sign it in front of the clerk, so you won't need a notary. If you are afraid to leave the clerk's office because you think you may have been followed, ask the clerk to call for help. Once you file the paperwork with the clerk, your petition will be reviewed by the judge, usually within 24 hours. Each petitioner's situation is different. Always choose the domestic violence form if your relationship with the other person qualifies you to file under the domestic violence statute. This means the other person could be your spouse, family member, or other parent of your child.
Wait, my boyfriend and I dated for 2 years, and yesterday we had another huge argument and he pushed and slapped me. I really want him to stay away from me. We don't have a child together and we never lived together. Does this mean I can't get help?
Actually, you can get help. But in your situation, you would not be able to file for a domestic violence injunction. Instead, you may be able to file for a dating violence injunction. You are eligible for a dating violence injunction if the following are all true. You dated in the last 6 months, and you had an expectation of affection or had sexual involvement with the respondent, and you interacted with the respondent on a regular basis during the relationship, not just one time.
What about me? I met him online. We went out once almost 3 months ago. He just won't leave me alone. He's made all kinds of fake accounts on social media pretending to be me. He's trying to hijack my accounts. My video doorbell shows him driving by my house at all hours of the night. Yesterday, he came to my work. Every day, I get over 100 texts and emails, even though I told him to stop, blocked him, and changed my phone number. This is crazy. I'm really afraid of what he might do next.
Since you only went out once, you would not qualify for a domestic violence or dating violence injunction. But you may qualify for what is called a stalking injunction. This statute requires 2 or more incidents of someone stalking or cyberstalking, meaning someone followed, harassed, or engaged in cyberstalking that caused substantial emotional distress and served no legitimate purpose. If you don't qualify for a domestic violence, dating, or stalking injunction, you may be eligible for a sexual violence injunction. To be able to file for this type of injunction, you must have already reported the incident and cooperated with law enforcement. You can also file if the perpetrator was sentenced to state prison for sexual violence against you or your child and has been released from prison or is going to be released within 90 days of when you file. There is also another type of injunction in Florida that is called a repeat violence injunction, involving violence from neighbors, co-workers, students, relatives who have never lived together, friends, or roommates. To qualify, you must have experienced 2 incidents of violence or 2 threats of violence that made you feel fearful of the other party. Remember, a domestic violence injunction does not require any physical violence, just a well-founded fear of future violence. But a repeat violence injunction requires 2 actual incidents of violence or threats of violence. No matter which type of petition you file, if the judge grants your request, the respondent cannot have any contact with you. This means no contact by phone, email, text, letter, social media, through third parties, or in any other way. The judge can order someone to stay away from your home, car, work, school, place of worship, or any other place the judge feels is necessary for your protection.
The police arrested my grandson, and a paralegal from the state's attorney's office called and told me the judge issued something called a criminal no contact order. Is that the same as an injunction? Do I even still need an injunction?
There are some important similarities and differences between a criminal no contact order and an injunction for protection. Both orders would forbid your grandson from having contact with you and allow the police to make an immediate arrest if the order is violated. Both orders can forbid your grandson from having possession of a gun or ammunition. And both orders can allow your grandson to come back to your house one time with the police to get clothing and personal items. But unlike an injunction, a criminal no contact or stay away order cannot specify who lives in the home, nor can it order the police to help place the petitioner back in possession of the home. If a couple has children, an injunction can include decisions about where the children live, time sharing, child support, and other things. Injunctions can last indefinitely, but criminal no contact and stay away orders end when the criminal case closes. Remember, the decision whether or not to file an injunction is always yours. The court's online e-filing website can be accessed easily from any computer, tablet, or smartphone. You begin by going to the online portal and registering. You just need to enter some basic information, create a password, and make a security question. Then check your email for a confirmation email. Once you click the link at the bottom of the email, your registration is complete and you can use the e-filing portal. It's important to create or use an email address that the respondent cannot access. Once you are registered, you will be able to choose the correct form for your situation. you would pick the form for a domestic violence injunction because you are married to and have lived with the respondent, your wife. Then the website will lead you through the questions to help fill out the petition automatically. You can find additional useful links and features there as well. Completing the form to petition for an injunction is the first step. Some additional forms are also required. If they are not available on the website, you can get them at the clerk's office. Once you have completed the petition and any other necessary forms, the next step is to make it official and file it with the clerk. First, you should print out the completed petition and make a copy. Then you can either get the petition notarized ahead of time and bring it to the clerk, or bring it directly to the clerk, who will swear you in and ask you to sign it there. Either way, be sure to bring the petition, the copy, and your ID. The clerk will stamp your copy and give it back to you for your records. One of the advantages of going to the courthouse in person is that you can ask lots of questions and learn more about local court procedures. Always ask the clerk if you are not sure about something.
Do you have this in Spanish?
Yes, I do.
If you can't read well or don't speak, read, or write English well, you can take the blank form home and get someone to help you, or use an online service that translates documents. You may also ask the clerk to make arrangements to have a certified language interpreter at your court hearing. If you need accommodations for any disability, including hearing loss, please let the clerk know ahead of your hearing. Ask the clerk when and how you'll be notified of the judge's decision. Get the phone number to call if you want to follow up. Find out when you can expect a call or paperwork in the mail. If necessary, give the clerk a safe alternate mailing address where you can receive the papers with the judge's decision. Whatever order the court issues, you are solely responsible for understanding and following all terms in the order.
What should I write in the petition? Can the clerk or advocate help me with that?
The clerk or advocate can help you with general information, but they can't give you legal advice or tell you what to write. They can show you the forms for different types of injunctions, but you must decide which one you want to file. No matter which form you choose, there will be a section that asks you to explain why you need the injunction. If you handwrite your petition, be sure to write clearly. Block printing is best. If you need more space to write, ask the clerk for a blank page. Do not write on the back of the form. It's a good idea to start your explanation with an introduction. For example,
I am filing against my boyfriend of 9 years. We live together and have 3 children. He is on the lease.
I'm filing against a respondent who I met once. He has been repeatedly stalking me in person and online.
Next, describe the most recent incident that made you decide to file.
I typed that on November 11th, my wife began banging on the door at 3 o'clock in the morning at her former home. When I didn't answer, she stood in the driveway and began breaking the windows out of my car. Then, she took out a knife and started slashing the tires. I called the police, but she ran away before they arrived.
I wrote on November 10th, early in the morning at our apartment, my boyfriend got furious when his work shirt wasn't ironed. He grabbed me by the feet and dragged me out of bed. I hit my head on the floor and he jumped on top of me and started choking me. Our 6-year-old saw everything.
If there have been other serious incidents, describe them in as much detail as possible. List them by date and location. The judge will not be able to legally consider any incidents not written in the petition. Make sure to write and tell the judge if you fear immediate violence and why you think it may happen soon.
I let the judge know that my wife is mentally ill and is not taking her medication. She's in a very angry, manic, and dangerous state right now. I know she will come back and hurt me, and I think violence is imminent.
The only thing the judge will consider is what you wrote in your petition.
I wrote that I need to stay in the house with the 3 kids. We have nowhere else to go. Even though he is on the lease, I pay the rent and his family lives in town.
I emphasized that I want the judge to order the police to take his guns when they serve him.
Now what happens?
If the judge decides to grant your petition, you will get a temporary injunction. Then you usually need to go back to the courthouse to pick up a certified copy of the temporary injunction and an additional set of papers called an emergency service package. If the judge decides not to grant your petition, a temporary injunction will not be issued. In this case, you can pick up your paperwork at the clerk's office, where you can ask the clerk for a supplemental petition form. Here, you can write more facts to explain why you are in fear of imminent danger. This form will be given to the judge, who then may or may not issue a temporary injunction or set the case for a hearing. If your petition is not granted, a temporary injunction will not be issued, but there are more actions you can take, and we will explain these later. Either way, be sure to read over all the papers and ask any questions before you leave the clerk's office. Then keep the papers with you or in a safe place in case you need to show them to the police. If an injunction was granted, the clerk will send law enforcement a copy of the injunction or a notice of a return hearing if the injunction was denied. An officer will go to the place or places you listed in your petition to serve the injunction on the respondent. The respondent must be served by law enforcement before your final hearing can be held. It is important for you to write all the possible addresses or general locations where the respondent might be found. If the judge issued a temporary injunction and the respondent comes near you while the case is still pending, call 911 immediately, even if he or she is not behaving violently. Let the 911 operator know that you have an injunction and the respondent is near you at that moment. In your hearing, let the judge know if the respondent violated the temporary injunction at any time. If the respondent violates an injunction they have already received and is present when law enforcement arrives, they will be arrested for violating the injunction. If the respondent has not been served yet, law enforcement can use your emergency service package to serve the respondent and order them to stay away from you.
The judge granted my domestic violence injunction, and it says that I can live in the house and the police will remove my husband from the home. How does that happen?
Take the injunction and emergency service package to the police station nearest to your home. If possible, call first to see if there is a particular time or station that is best to go to for this kind of help. The police will accompany you back home, serve your spouse with the injunction, and order him to leave and stay away from you in the home. He will be allowed to quickly pack clothing, medication, and personal items. If the injunction requires the respondent to surrender all firearms and ammunition, the police should take temporary possession of any of those in the home. While an injunction is an important tool to help keep you safe, an injunction cannot stop violence if someone is intent on committing violence, even if there is a court order. Take homicidal or suicidal talk or actions very seriously. At a minimum, change the locks and secure the house. If you still don't feel safe and don't have a safe place to live temporarily, consider going to a domestic violence shelter.
I went back to see the clerk, and there was an order denying my petition and setting the case for hearing in 2 weeks. That's not fair.
Here, the judge did not grant the petition, but instead decided to only set the case for a hearing. You will have no protections during the time before this hearing, but your petition and notice of hearing will still be sent to law enforcement, who will try to find and serve the respondent. If you feel unsafe having the respondent served with no temporary injunction in place, you can withdraw your petition and add more information to it before refiling. In some locations, there is a form you can complete before the judge reviews your petition that gives you the choice to refuse a hearing-only decision by the judge. If you refuse a hearing-only decision, your case will be dismissed, and the respondent will not be served with any papers. Even if you do not refuse a hearing-only decision, you still will not be granted any protections. You should decide whether or not to refuse a hearing-only decision based on what will be safest for you. If you decide to go forward with the case and either did not file a supplemental petition or filed one without an injunction being granted, a final hearing will be set in about 2 weeks. There, you will have another chance to present your case to the judge.
I got my injunction, and my ex-boyfriend has been staying away. Now I'm worried about what will happen in the hearing. Who will be there? What do I say in court?
We'll be answering those questions and more in the next section.